I'm comfortable. I'm a teacher, my lord.
Now, my lords, in Exhibit E, there are votes assigned to the petitioner and the second respondent and all the other presidential candidates. Is that not so? That's on the last page of Exhibit.
By the first respondent, yes.
Now, what we have here is 677-6066 for the second respondent. Is that correct?
From where, please?
That's the total,
yeah, the
total valid votes.
Yeah.
Is that correct?
6,776,066.
That's what is on it. Is that correct?
I don't know. Yes, it's in this statement.
Yes.
Yes.
And then also for the petitioner, we have 6,265,276. Is that correct?
According to the document submitted by the first respondent.
It is your document we are looking at, please. Now, look below the figures we have just gone through. For the second respondent, there's a percentage of 5.126. It is down there. That's 51.126. Sorry, 51.261. The way we have rendered it, that's fine. 0.5, yes. 0.51261,472. Is that correct?
That's correct.
Now, I am suggesting to you that this works to a percentage of 51.2614.
Percentage of what?
A percentage of the total valid votes also on this sheet.
It's 51.263%.
Yeah. Right. Now, for the petitioner, we have 47.397 assigned to him by your sheet. Is that correct?
47.397. Yes.
Right. That's correct. Now, deduct the number assigned to the second respondent. No, deduct the number assigned from the petitioner from that assigned to the second respondent and tell this court the difference.
Which of the numbers? You asked about percentage.
6,
you are now asking
6, 7, yes, I've moved on from percentage. 677,6066 minus 62,65276. What do you get?
As it's not that good, I think you'll be stretching the witness about 510,790.
Thank you very much.
It's okay.
Yes. You got 510,790.
Yes, my lord.
Right. Now, it is not true that the first respondent padded votes as you allege. I'm putting it to you.
My lord, I decline that assertion.
Now, in your exhibit F, you allege that 4693 votes was added in favor of the second respondent. That is the allegation.
My lord, if you look at my statement, I indicated that I will bring a sample of the constituencies and polling stations where padding took place. I did not indicate that is an exhaustive list of all the places where the padding took place.
So we are using the numbers that you have brought to the court to assess the court. I am saying that the total of 4693 is what you have put in there. Is that it?
I brought it as a sample. I did it in my statement. Actually indicates that this is from a sample of this particular perspective. I don't understand sample to mean total of the population.
Now deduct the 510,790. We deduct the 4, deduct the 4693 from 510,790. What do you get?
With all due respect, I don't see the point of the.
With all respect, you are being rude to the court, not to me.
Okay. Yeah, come again.
And so that we deduct 4693 from 510,790. What do you get?
I got 506,097.
Good. I am suggesting to you that even if this your number as alleged, which is denied, even if it is deducted from the total valid votes of the second respondent, he still has won by your own sheet by 51.246%. I'm putting it to you.
My lord, I deny that because we are subtracting apples from mangoes. But this is a sample. You want to take a sample from a population of another people. I don't see where the calculation
can be seen. I am suggesting to you that you have no evidence to support your allegation. That is why you have brought only what you have. I am putting it to you.
We are not in court to try to declare another presidential it was by us. We are in court to challenge the performance of a constitutional duty of a first respondent and to see whether that duty has been discharged safely.
If that is so, then I'm suggesting to you that you are not, by your own showing, you are not in the right forum.
I claim that, my lord.
Now you have earlier told this court that you cannot speak to what happened in the strong room when the two representatives were there.
Yeah.
So that's correct.
That's correct.
Because on that basis, I'll end my cross-examination of the witness.
Yes, my lord. I do. So, Mr. Asiedu Nketia, you recall recall that before the declaration of 7th of 9th January 2021, December 2021. Relax. 9 December 2020. Your party and your presidential candidate held a series of press conferences on what you consider to be the outcome of the elections. Is that not so? It is so, my lord. In those press conferences, you announced to the whole world that the petitioner had won the presidential elections and was by the votes you had collated the president-elect. Am I correct? My lord, that is not in my witness statement. So can you answer that question? You did say so. Didn't you? Come again. I said your party, including your good self, and the first petitioner, the petitioner, and also one Otokuno, your deputy, together with other leading members of your party, you held several press. So, I'm putting to you that your party held a number of press conferences. Yes, my lord, that is so. Now, in those press conferences, or in some of them, you were present and you spoke on the issue of the results of the presidential elections. Yes, my lord. The petitioner himself also spoke on the outcome of the presidential elections. Yes, my lord. And your as deputy, Tokuno, equally spoke on the results of the presidential elections. My lord, I can attest to my statement at the forum where the petitioner was present and he spoke. But I don't remember being present at a forum where my deputy spoke. Now, you know that your presidential candidate, that is a petitioner, asserted that he had won the 2020 presidential elections. What Ghanaians had voted for change. And what I remember the petitioner said was that the results are declared by the first respondent is not accurate. Now, I'm also putting it to you that you yourself declared that the petitioner had won the presidential elections. Unless I'm reminded, but I remember saying that NDC has won parliamentary majority in parliament, and that gives President Mahama a comfortable situation to be able to run the next government. So I'm suggesting to you that by that statement, you were saying that the petitioner had won the elections and was going to become the president. There were all indications that he was going on, and it's not indications. I'm saying that by what you said, you meant that he had won the elections, but that was the only way he could form the next government. And Lord, if I meant that, I would have said so. Mr. Asiedu Nketia, we served on the petitioner our witness statement. You are aware? Lord, I'm not the petitioner. I didn't say you are the petitioner. I said we served on the petitioner our witness statement. Yes, I'm aware we have been served. Have you seen a copy of the witness statement? Yes, I've seen it. Do you admit that in the witness statement of the petitioner, of the second respondent, we have attached Exhibit 6. Exhibit 6. 6. Yes, sir. Hours. We're looking for hours. Yes, can you answer? Yes, I've seen this. So we presume that you know the contents. So we presume that you are speaking, you know the contents of that video clip. Well, my Lord, I have not played the contents, so I cannot testify that I know what is contained there. My Lord, I would need some direction here. This is a problem that arises at trial in the High Court. Our witness is not at that moment giving testimony. A witness on the other side is giving testimony, and you want to confront him with material or exhibits in your witness statement. In our witness statement, to discredit him, what he's saying. Now, at the time that he would have finished his evidence and stepped out, when we leave that evidence, he will not be available to respond to the content of that evidence. We want to play the video so that you exactly. Yes. Very well. Yes. Mr. Yes, my lord.
You are conducting your case, so if at a point you think that there is evidence which you want to make an application to the court to allow you to either show to the court, you have to put that application before the court. But as it is, you have not made any application. You have to give the other side the opportunity to respond. What you're asking is you want directions from us.
Yes.
So you know what to do.
If you leave the oral application to have the video that we attach to our witness statement played out, so that we can properly confront the witness with his own acts and that of the petitioner, together with leading members of his party, and the issue whether or not they declared to the Ghanaian public that petitioner had won the election.
You have to address us on relevance. So what is the relevance? What would this video establish?
The relevance is that if that they had all the necessary page sheets to demonstrate that they won the elections. When they came to court finally, after a lot of pressure from the public that if you won't come to court, all they are saying is that if you use the errors
an election, that should be taken as the law. No, we have laws, we have regulations, and how how to declare our results.
My lords,
you have your witness statement together with this, would I say, proposed exhibit.
yes. And my Lord, I'm saying that this is a difficult thing. We are talking about of the petition. In respect the credibility or lack because it's been very evasive.
The challenge we have is that you did not give any indication prior to this hearing. Want a video to be played.
It's attached to our
Mr. Registrar, I'm not sure whether there is any provision made for that. Do you want? Yeah.
believe that we have not been heard. There have been several steps of questions. We have not been heard even in respect of his basic attempt. Okay. Attempt. Okay. Submission. The application. She said